Hi everyone. Today I will talk about one new topic, that is natural justice. So what will be the principle of natural justice? In our next few slide, I will talk about principle of natural justice, definition of natural justice, that means what is natural justice, purpose of the principle, rules of natural justice, and finally we find out some summaries. Principle of natural justice is derived from the word jus natural, which was a Roman law, and it is closely related to common law and moral principle, but is not codified. It is a law of nature which is not derived from any statute or constitution. The principle of natural justice is adhered to by all the citizens of civilized state with supreme importance. In the ancient day of fair practice, at the time when industrial area ruled with a harsh and rigid law to hire and fire, the Supreme Court gave its command with the passage of duration and establishment of social justice and economic statutory protection for the workman. Natural justice is an expression of English common law and involves a procedural requirement of fairness. The principle of natural justice has great significance in the study of administrative law. It is also known as substantial justice or fundamental justice or universal justice or fair play in action. The principle of natural justice are not embodied rules and are not codified. There is no precise and scientific definition of natural justice. However, the principle of natural justice are being acceptable and enforced. Different judges, lawyers, and scholars define it in various ways. Lord M.R. has defined it as the natural sense of what is right and wrong. Later, he has chosen to define natural justice as fundamental justice in a subsequent case. Lord Parker has defined it as duty act fairly. Mr. Justice Bhagwati has taken it as fair play in action. Article 14 and 21 of Indian Constitution has strengthened the concept of natural justice. Natural justice simply means to make a sensible and reasonable decision-making procedure on a particular issue. Sometimes it does not matter what is the reasonable decision, but in the end, what mattered in the procedure and who all are engaged in taking the reasonable decision. It is not restricted within the concept of fairness. It has different color and shade which may vary from the content. Basically, natural justice consists of three rules. The first one is hearing rule or hearing rule, which states that the person or party who is affected by the decision made by the panel of expert member should be given a fair opportunity to express his point of view to defend himself. Secondly, bias rule generally express that panel of experts should be biased free while taking the decision. The decision should be given in a free and fair manner which can fulfill the role of natural justice. And thirdly, reasoned decision, which state that order, decision or judgment of the court given by the presiding authority with a valid and reasonable ground. Purpose of principle. The principle of natural justice should be free from bias and parties should be given fair opportunity to be heard, and all the reason and decision taken by the court should be informed by the court to the respective parties. Supreme Court said that arriving at a reasonable and justifiable judgment is the purpose of judicial and administrative bodies. The main purpose of natural justice is to prevent the act of miscarriage of justice. A committee, that is ministered power, gave three essential procedures related to the principle of natural justice. They are: no one should be a judge in his own matter. No one can be commended unheard. The party is entitled to know each and every reason and the decision taken by the authority. Now, when it can be claimed, natural justice can be claimed when acting judicially. Like panchayat and tribunals. As well, it includes the concept of fairness, basic moral principles, and various different kinds of biases, and why the natural justice is required, and what all special cases of situation it includes where the principles of natural justice will not be applicable. Rules of natural justice. The principles of natural justice originated from common law in England are based on two Latin maxims which were drawn from just natural. Rules of natural justice. In simple words, English law recognizes three principles of natural justice as stated below. The first one will be nemo judice in casus suo. That means no man shall be a judge in his own cause. The second would be the AUDI ALTERAM pattern, or the rule of fair hearing, or hear the other side. And the third one will be reasoned decision. Now we will talk about bias rule. That means these rules will be discussed in detail. So, how many types of bias will be possible under natural justice? Personal bias, precautionary bias, subject matter bias, departmental bias, policy motion bias, bias on the account of obstination. First one will be the personal bias. Personal bias arises from a relation between the party and deciding authority, which lead the deciding authority in a doubtful situation to make an unfair activity and give judgment in favor of his person. Just equation arise due to various forms of personal and professional relation. In order to challenge the administrative action successfully on the ground of personal bias, it is necessary to give a reasonable reason for bias. Supreme Court held that one of the members of the panel of selection committee, his brother, was a candidate in the competition, but due to this, the whole procedure of selection cannot be quashed. Precautionary bias. If any of the judicial body has any kind of financial benefit, howsoever small it may be, will lead to administrative authority to biases. Subject matter bias. When directly or indirectly the deciding authority is involved in the subject matter of a particular case, the court refuses to quash the decision of election tribunal on the ground that the chairman's wives were a member of Congress party whom the partition defeated. Departmental bias. The problem on issue of departmental bias is very common in every administrative process, and it is not checked effectively, and on every small interval period it will lead to negative concept of fairness will get vanished in the proceeding. Policy notion bias. Issues is arising out of pro-convinced policy notion in a very dictated issue. The audience sitting over there does not expect judge to sit with a blank sheet of paper and give a fair trial and decision over the matter. Bias on the account of abstentionism. Supreme Court has discovered new criteria of bias through the unreasonable condition. This new category emerged from a case where a judge of Calcutta High Court upheld his own judgment in appeal. A direct violation of the rules of bias is done because no judge can sit in appeal against his own case. The second rule will be the AUDI ALTERAM pattern. It simply includes three Latin words, which basically means that no person can be condemned or punished by the court without having a fair opportunity of being heard. In many jurisdictions, a bulk of cases are left undecided without giving a fair opportunity of being heard. The literal meaning of this rule is that both parties should be given a fair chance to present themselves with their relevant point and a fair trial should be conducted. This is an important rule of natural justice and it is pure from is not to penalize anyone without any valid and reasonable ground. Prior notice should be given to a person so he can prepare to know what all changes are framed against him. It is also known as a rule of fair hearing. The components of fair hearing are not fixed or rigid in nature. They vary from case to case and authority to authority. Now, there will be some exception on applying this rule. It cannot be applied during the emergency period. Always consider public interest before take of any decision. It should express statutory provision. Nature of the case should not be a serious kind. If it does not affect the statute of the individual, then it should not be applied. Natural justice is applicable to some of the following points. The first one will be the court except to ex parte. Next will be the tribunal. And last but not the least will be the authority entrusted with direction but subject to legal limitation. The third and final rule is reasoned decision. Basically, it has three grounds on which it relies. The aggrieved party has the chances to demonstrate before the appellate and revenutial court that where was the reason which make the authority to reject it. It is a satisfactory part of the party against whom the direction or decision is made. The responsibility to record reason work as obstacle against arbitrary action by the judicial power vested in the executive authority. So, we can conclude as the principle of natural justice have been adopted and followed by the judiciary to protect public right against the arbitrary decision by the administrative authority. One can easily see that the rule of natural justice include the concept of fairness. They stay alive and support to safeguard the fair dealing. So at all stage of the procedure, if any authority is given of the judicial function is not purely accepted, but the main motive of the principle is to prevent the miscarriage of justice. It is supreme to note that any decision or order which violates the natural justice will be declared as null and void in nature. Hence, one must carry in mind that the principles of natural justice are essential for any administrative settlement to be held valid. The principle of natural justice is not confined to restricted world, the applicability of the principle, but depends upon the characteristics of jurisdiction, grant to the administrative authority, and upon the nature of right affected to the individuals. So that's all about you. Thank you. If you have any doubt, you can talk me in the class.